The Employment Non-Discrimination Act has sought to amend Title VII to add sexual orientation and gender identity. This is a pending bill that actually would have already passed, but there was a huge fight in Congress about whether or not transsexuals should be covered. If Congress had moved ahead without the transsexual or folks that have had gender identity issues, if they had chosen to move ahead without adding that provision in there, I'm 99% confident that it would have passed, that Title VII would now add sexual orientation to the protections of race, sex, national origin, and religion. It didn't. I will tell you again, if I was going to look in my magic ball and look into the future, I will tell you at some point in time, I expect Title VII to be amended to add sexual orientation. And already there are a number of local and county ordinances that prevent sexual orientation discrimination. I will tell you just sort of a word to the wise that no matter how zealously or firm you are in your beliefs about sexual orientation, it's a bad idea to base any of your employment decisions about whether or not somebody, who they choose as their partners. I would highly recommend you stick with more objective reasons, like they weren't the best one for the job. Also, other pending legislation is the Breastfeeding Promotion Act. This is going to amend the Pregnancy Discrimination Act provisions of Title VII to include lactation and require employers with 50 or more employees to provide a reasonable unpaid break time for employee to express milk for a nursing child for 1 year, and provide a private place for them to do that in a bathroom or other room. This is one of those things that I think is somewhat of a no-brainer, and let me tell you why. Just about every employer already allows somebody to take smoke breaks or some other break. You're going to have a hard time, even if this law doesn't pass, you're going to have a hard time saying we allow folks to take 15 minutes to smoke a cigarette, but we're not going to give them 15 minutes to breastfeed a child. So this is one of those things. I would assume I would act as if this is already passed if you want to avoid yourself a lot of potential grief in the future. Title VII's Fairness Act. This is going to amend Title VII of the ADA to delay the start time period for filing charges of employment discrimination until the complaining person has or should have enough information to support a reasonable suspicion of discrimination. This proposed bill is a huge problem from employers. In the past, somebody has to act pretty quickly within a year to file a charge of discrimination under Title VII or the ADA, or their claim is lost, meaning the statute of limitations run. Now you're going to run into every single plaintiff says, well, I didn't know I was being discriminated against till well after. They may say, hey, my buddy John told me 6 months after I worked for you that a year before I was terminated, they wanted to get rid of all the women, or they wanted to get rid of all the Muslims, whatever the case may be. So this could drastically change things because it can become a more subjective analysis, and every plaintiff's attorney is going to try to coach their client up into saying, well, just tell them you didn't know you were being discriminated against till well after you actually brought your charge. It's going to be a huge problem if it gets passed. Employment-related arbitration. In 14 Penn Plaza versus Pyatt, court held that arbitration provisions in a collective bargaining agreement, which clearly and unmistakably require union members to arbitrate ADA or age claims, are unenforceable. For those of you who use arbitration clauses, don't even worry about whether or not you have unions or not, or a collective bargaining agreement. I will tell you, as personal preference, I do not like arbitration provisions. I know some of you on this call may have them. Let me tell you why I don't like them, and let me tell you what I would recommend instead. The problem with arbitration is if a case is arbitrated, I think a lot of people think that it's going to be a less costly alternative to actually having to go through litigation. I will tell you, as somebody who has arbitrated hundreds of cases and litigated hundreds of cases, that it is not true. It normally costs just as much to go through arbitration. The second problem with arbitration is arbitrators are paid by lawyers, unlike judges who are paid by the court system and are up for re-election or appointed for life, don't have the same motivations. An arbitrator, their record is typically going to be public. So whenever I've got a case where it's going to get an arbitration, the first thing I'm going to do is going to look at the panel of prospective arbitrators and say, okay, is arbitrator 1 through 10, what have they done in the past? Are they pro-employee or are they pro-employer? Obviously, all of the pro-employee arbitrators I'm going to want to strike. All the pro-employer arbitrators, the other side's going to want to strike. So what happens is you end up with a panel, typically, and this is not always true, but a panel full of people that are right in the middle, that play Hammurabi, that split the baby in half and give each side something. So both sides, in essence, lose. So while we win, at least in my firm, we win a lion's share of our cases in litigation well before we ever go to trial, and still win most, if not all, of our trials. In arbitration, you almost never win. They're almost always going to give the other side some money, and that's the problem with arbitration. So I promise y'all that I'd tell you what I recommend instead. What I recommend instead, where you can, and not every state will allow you to do this, I recommend that you all implement what are called jury trial waivers and also class action waivers. At least in Florida, I've done this numerous times, and they were enforced by the court, where if somebody sues you, they can't bring a jury trial claim. They have to have their case decided by a judge. This is important because I will tell you, jurors rarely decide cases based upon the facts or law. They normally do what they think is fair or the right thing to do. Most jurors, if you read the studies, are going to lean 70 or more % towards the employee. Even if they don't think the company did anything legally wrong, if they didn't treat that employee in their view fairly, they're going to allow the plaintiff to win. So that's a problem. So to take that wild card, a jury who is not going to be necessarily a jury of your peers, more a jury of the peers of the plaintiff, what I recommend is you all institute what are called jury trial waivers. If you're interested in exploring this or class action waivers, feel free to reach out to me after this call. But they are enforceable, and they're a great arrow in the quiver of employers to prevent litigation. I will tell you the reason we see so much new employment discrimination from the 90s and the 2000s is not because of the high-profile cases with Bill Clinton or Clarence Thomas, but actually because they changed Title VII, or they changed the discrimination law to allow jury trials in 1991. Now every person you see on the phone book says, hey, I want to become an employment lawyer because I've got another way to get in front of a jury. So I like to take that incentive away from the other side. It's far more likely that a judge will say, wait a minute, Jane stole your stapler and didn't show up to work 30 days in a row. That was the right decision to let go of them, rather than a juror who may be sympathetic to Jane and say, well, yeah, she stole your stapler and didn't show up to work on time, but she's really poor, and I feel bad for her, so I'll give her something. In employment cases, if they give the other side something, even if that something is a nominal amount, it will absolutely still cost you a fortune, because then you'll have to pay the other side's attorney's fees. So again, not to beat a dead horse, but I highly recommend. I'm not a fan of arbitration. I am a huge fan, though, of implementing jury trial waivers and class action waivers. And I think this case is one indication that it's going to be harder and harder for employers to use binding arbitration anyway. Move on to the next decision. The Arbitration Fairness Act would make it valid and unenforceable pre-dispute arbitration agreements that require arbitration of an employment, consumer, franchise, or civil rights dispute. In the past, court systems have very much been in favor of arbitration because it's one less case on their schedule. There are a lot of unions and pro-employee groups, and the pro-employee groups are in office right now, who have been pressing to get the Arbitration Fairness Act. Again, I told you at the beginning of the speech, anytime the word fairness or free is in the title of the law, it's neither free nor fair for the employer. This is another way they're going to try to stick it to the employer and not even allow you to have arbitration. So I like to stay I like my clients to stay one step ahead of the curve, and I would implement jury trial waivers again.